And welcome to this edition of The Right Stand. I'm Anand Narasimhan. It was an interesting day in court today, ladies and gentlemen, in the Supreme Court, as the Supreme Court had some very scathing observations against the conduct of the Speaker of the Maharashtra Assembly, the Governor of Maharashtra at that time, Bhagat Singh Koshyari, but eventually turned around and said, had you not resigned, we could have given you relief. That was the message to Uddhav Thackeray, while Eknath Shinde and Devendra Fadnavis were told, well, your government stands as of now. The aspect of disqualification goes to the Speaker, and as far as whether or not the name Shiv Sena will be retained by Eknath Shinde faction will be decided by the Election Commission. Now, sympathy for Uddhav, relief for Shinde, that's what we saw. The outcome of the Supreme Court's order in June 2022, Uddhav Thackeray stepped down from the post of Maharashtra Chief Minister after Eknath Shinde and his MLAs revolted against the Maharashtra Vikas Aghadi or Maha Vikas Aghadi. Now, with this, it paved the way for a new government, and on 30th of June 2022, Eknath Shinde took oath, passed the floor test as Chief Minister of Maharashtra with Devendra Fadnavis as his deputy. The MVA quick to move the Supreme Court seeking relief, but even 10 months after this entire turmoil, the court not in their favour, pointing to that aspect. There were illegalities, there were what the court observed as actions wide the constitution by the governor in office at that time. But Uddhav Thackeray cannot be restored back as Chief Minister since he resigned voluntarily, and that's why the government can't be brought back. Court recognizing that both the then Maharashtra Governor and the Speaker did not act in the appropriate manner as per the constitution or the laws prescribed. However, the decision to disqualify 16 MLAs lies with the Speaker. Larger question is, will this entire resign damage end the Aghadi? Because the NCP, Sharad Pawar, has very clearly blamed Uddhav Thackeray and told him, I was upset, and he's ready to return it in his autobiography also. I was upset that Uddhav took the decision without even speaking with his partners in the Aghadi. So what are the takeaways? Let's quickly have a look at that. The Supreme Court said that it cannot ordinarily adjudicate petitions for disqualification under the 10th schedule in the first instance, and the Speaker must decide disqualification petitions within a reasonable period. But they still did not stipulate the period. There are many who believe it should happen fast and not over a long period of time. There shouldn't be inordinate delay. Takeaway 2. Supreme Court also said that the MLAs have right to participate in the proceedings of the House regardless of the pendency of petty petitions for their disqualification. Now this again, it's quite a question mark. But they said you continue to dispose of your duties till the time the Speaker hears about the disqualification. The Supreme Court also said Speaker's decision to appoint Gogavle of the Shinde faction as the chief whip of the Shiv Sena party was illegal. Takeaway 4, Supreme Court says that the Election Commission of India must look into the other tests to decide on symbols and also who holds the name, which Uddhav Thackeray believes nobody can take the name. He says, I cannot take my name. Take the name away of the party. We can appropriate the symbol or give it away to somebody else, but not the name. Slamming the governor, the Supreme Court said it was not justified for the governor to call on Uddhav Thackeray to prove a floor test. There was no reason because it's not written on paper. The court said that that status quo ante cannot be ordered by restoring the MVA government in Maharashtra, as a former Chief Minister Uddhav Thackeray did not face a floor test ahead of resignation. Further, the Supreme Court stated that the governor was justified in inviting Shiv Shinde to form the government in the state of Maharashtra post the resignation of Uddhav Thackeray. Supreme Court wrapping Maharashtra Governor, the Apex Court said resolution relied on by the Maharashtra Governor didn't indicate MLAs wanted to withdraw support. It had no material to call for the floor test, and that the Governor can't use floor test to settle inter and intra-party disputes. The Supreme Court observed that the Governor erred in relying on resolution of faction of MLAs of Shiv Sena to conclude that Uddhav Thackeray had lost the majority. Slamming the Governor, India's top court said the exercise of discretion by the Maharashtra Governor was not in accordance with the Constitution of India. Massive war of words thereafter erupted. Soon after, the Shinde government was formed with the rivals illegally, is what Uddhav Thackeray said. Shinde's counter was that the Supreme Court verdict proves the government is legitimate. Uddhav Thackeray's charge was the whip appointed by the Shinde faction was illegal. But the counter that came is Uddhav Thackeray resigned as he did not have majority. Uddhav Thackeray's charge is Shinde should resign on moral grounds. So should Devendra Fadnavis. But Uddhav Thackeray and the Shinde counter is that Uddhav can't preach us on morality, because where is the morality when you quit the Gathbandhan and joined the Aghadi just because you wanted to be Chief Minister? So where is morality? Don't teach us morals and morality. Uddhav Thackeray's charge, democracy being murdered in India. Shinde's counter, it's a victory of democracy after the Supreme Court's verdict. Let's go across to our guest joining us this evening, former Maharashtra Chief Minister, very senior Congress leader Prithviraj Chavanji joins us. Namaste, sir. This is Anand Narasimhan. Good to speak with you. 2 days on the 2 days on the run.
Yeah.
But today, what's happened in court and what has happened thereafter? How would you see these developments, sir?
Well, it's a very, very unfortunate development. The Supreme Court rightly has passed very, very nasty strictures against the governor, the speaker, and the election commission. But unfortunately, the wrong decision, unconstitutional decision by the governor to call for a floor test when the option of a no confidence motion was available to the opposition was blatantly illegal, unconstitutional. But the impact was Mr. Uddhav Thackeray resigned. There was a vacancy and a new chief minister was sworn in. First you hang a man and then you say, I'm sorry, I made a mistake. Now you cannot revive that thing. It's a very unfortunate murder of democracy. All the constitutional institutions, the election commission, in deciding that the Shiv Sena belonged to Shinde group, erred because they did not look at the organizational side of the thing. They only decided on the legislative and the parliamentary majority, which was wrong according to the Honorable Supreme Court. Secondly, governor was blatantly wrong in ordering a floor test. Thirdly, the speaker also erred in the 3rd July order. So everybody, all constitutional functionaries made a mistake, but the sufferer was the Mahavikas Aghadi government. Sufferer was Uddhav Thackeray. Now, once he resigned, a new chief minister had to be sworn in. That was all right because you couldn't have a vacancy in the post of chief minister. But now what to do? Supreme Court even went to the extent of saying if Mr. Uddhav Thackeray had not resigned, we could have considered restoring status quo ante, which means blatantly and prima facie the decision of the governor was wrong. It was unjust decision, unconstitutional decision. It caused a great hurt to the Mahavikas Aghadi. But the act having been done, now it cannot be revived.
Kahin na kahin,
you hang a person and then say, I'm sorry, I made a mistake.
But that can be also asked of Mr. Uddhav Thackeray. NCP Congress se pooch liya hota. Had you asked, then it would have stopped. Sharad Pawar ji has actually mentioned this in his autobiography also. That why didn't he ask us? He should have asked us.
I had given an interview. I had given an interview to one of the Marathi channels. Within half an hour of Mr. Thackeray's social media oration that he's resigning. I was shocked. Everybody was shocked. He did not consult anybody. There was a cabinet meeting about half an hour before his social media address, resignation speech. He did not mention anything to any one of us. So we are all shocked. So I immediately reacted that this is a great mistake. He shouldn't have done it. He should have faced the floor test, and if we have defeated there, so be it. But this is exactly what the Supreme Court has reiterated, that if Mr. Uddhav Thackeray had not resigned that day, we could have considered restoring status quo ante. Which means Supreme Court is agreeing that what happened was completely unconstitutional. They're willing to restore Mr. Uddhav Thackeray to Chief Minister's position, but now he had resigned and a new Chief Minister has sworn in.
But does that SAR equations?
The fine print.
Does that SAR equations within the Aghadi? Does that SAR equations
within
the Aghadi?
No, not at all.
Does that
not at all.
compel you to think, Congress to rethink and NCP to rethink whether they want to continue with
Not at all. Not at all. We are firmly with Mr. Uddhav Thackeray. The Mahavikas Aghadi is firmly together. It was an error of judgment. He should have acted in haste. But that has happened now. But the fact is, if you read the Supreme Court judgment, they have faulted every constitutional authority from the governor to the speaker to the election commission. So what does it speak of? What kind of a democracy are we running?
No, but let me ask you this, Prithviraj Chavanji. I remember that interview because I saw clips of that in where you were speaking in Marathi and said what you have done, what he is doing is wrong. But didn't somebody call Mr. Uddhav Thackeray and said, you made the announcement, but don't write it. Change your decision. Mat karo aisa.
Well, after having publicly on social media saying that I am resigning, वो उतना मुश्किल था. But let me tell you, after he resigned, we all of us, particularly Congress group of about 10-15 MLAs, all our leaders, we went to Matoshri to sort of console him. So it doesn't matter, this has happened, we are all with you. But he had also said in that speech that he was also resigning as a member of the Legislative Council. And I immediately advised him not to go ahead with that decision because it was only an announcement on television. But please don't do it because in the Legislative Council, the numerical superiority, the numbers, the majority, the who will become the chairperson of the council, all those things are important. So he listened to us and he did not resign from the council. He still is a member of the Maharashtra Legislative Council. But Chief Minister's decision about resigning as the Chief Minister, he spoke on the social media, on the Facebook, and immediately went to the governor's office. We did not have time to stop him.
So now what happens next, sir? What happens next? Do you believe Uddhav Thackeray has
the
called...
legal battle will continue.
How does the legal battle continue once the court says it is up to the speaker and it is up to the Election Commission of India?
Because the matter of disqualification of 16 MLAs now goes back to the speaker. Now speaker will have to adjudicate within the framework of the constitution. He cannot take a blatantly illegal or a partisan decision. If he takes that decision, we can go to court again. So this battle will go on. The Honorable Speaker will have to take a decision within the framework of the Constitution. And that matter is not yet settled. So the disqualification of 16 MLAs who have prima facie violated the 10th schedule of the Constitution, the anti-defection law, that has to be adjudicated. The Supreme Court said that we cannot do it, we do not have the power. The power remains with the Speaker of the Vidhan Sabha. So Speaker of the Vidhan Sabha will decide. Now, Supreme Court has said within a reasonable time frame. Now, what that reasonable time frame is, we don't know. Does it mean 15 days? Does it mean 1 month? Does it mean 6 months? Does it mean 1 year till the end of the term?
Yes.
So I think somebody will have to go and find out what that reasonable time frame is.
But is it actually worth fighting that legal battle, or should the focus be on taking it to the people, as Uddhav Thackeray also hinted, saying I want to go back to the people? You got the BMC elections, we don't know when it will happen, but it may happen. Then, like you said, with it by the end of the year, you are staring at again going back to the people for assembly elections.
Well, assembly election is a little later, is in October normally. Lok Sabha election happens in May. But of course, going to the people and telling what has happened will continue. But the legal team will fight the legal battle. When that will not stop, it is not either or situation. The legal battle will go on, we'll examine the judgment, we'll take legal advice, we'll take what are the recourse available to us. The Supreme Court judgment is so clear about unconstitutionality by all the constitutional functionaries, the Speaker, the Governor, the Election Commission of India. What does it speak about Indian democracy?
Well, we'll have to see, because the court has said wo resignation nahi hota to hum kuch kar sakte the. Now that you have resigned, we can't do anything. So should we resign to that fate, or?
Yeah, but the fact is, the fact is what the court said. You just look at the other side of the coin. He said if you had not resigned, we could have restored you. Now you could restore anybody unless a blatantly unconstitutional action has been taken place. So court has said indirectly that yes, what happened was completely unconstitutional. It was wrong. We could have given you redressal, but unfortunately you resigned and a new chief minister was sworn in. Which means the Supreme Court has said that what happened was unconstitutional, wrong, unjust.
Well, they have said that, but right now it is they continue to remain in power and they continue to muscle on 10, 11 months after that entire change. That change has happened. I thank you for your time. Always a pleasure speaking. But you're saying that the drama will continue because we'll see it's now into the court of the speaker and what happens with disqualification, and you say that the legal battle will continue.
Yes, of course, it will continue. I mean, we'll continue to seek justice.
And that
we will continue to seek justice.
And there is no break in the Aghadi.
Constitutional.
There is no split in the Aghadi. The Congress
no, that is out of the question. No, Aghadi remains even more steadfast. We are all together, we'll fight together, and we'll defeat this Sena, defeat this Shinde and Fadnavis government. That is why they are not even they are not holding the local bodies election. They are overdue for more than a year.
BMC elections.
They dare not hold elections because they know they'll be wiped out in the elections.
We'll see, sir. We'll see. One may just hear the announcement very soon. Perhaps everybody was waiting for this verdict before they take a step forward. Thank you very, very much. Thank you, sir. Prithviraj Chavan.
Yes, yes. Thank you. You're welcome.
Thank you, sir. Thank you. Let's quickly go across to Vikas Singh ji, the former ASG and president of the SCBA, joining us right now on the legal aspect. Vikas Singh ji, namaste, Jai Hind, thank you very much for joining us here at CNN News 18 on the right stand. How would you interpret today's decision of the Supreme Court, especially the scathing observations made?
So basically, the 10th schedule really has become a joke now. So there is no purpose of keeping the 10th schedule as it is. And I personally feel that the only way the sanctity of the 10th schedule can be maintained is if we let the speaker decide on disqualification in a summary manner. So like in a day or two, he should decide the disqualification, because if that disqualification happens, and if that happened and that had happened in this case, then this problem would not have arisen. But again, if you see, this is some kind of poetic justice, because Shiv Sena had fought this election in a combination with BJP, and then suddenly at the end, ideally its votes were part of BJP votes as well.
Yes.
And in fact, it was not justified for it to, have a split from BJP and made a government with the NCP and the Congress. So, in some sense, it is poetic justice in this case. But otherwise, overall, I have a huge difference of opinion with another judgment of the Supreme Court, which says that a person who defects or even suffers a disqualification can come back in the same house if the same seat is put for election again. So that, according to me, is not a correct interpretation of the 10th schedule, because once you are disqualified, you should be disqualified at least for the term of the house in which you got elected. So if that house is balanced term is say 3 years or 4 years or 5 years, whatever be the balanced term, this disqualification should continue. And if that judgment is not set at naught, the earlier Supreme Court judgment, I think really not much, teeth will remain in the laws with regard to disqualification under the 10th schedule.
But Vikas Singh ji, some of the other observations also in terms of the whip being declared illegal, with the court saying party decides the whip and not the leader of the legislative party inside the house.
So I think, of course, that's the right way forward, because otherwise, if the MLAs are sort of combining to, support somebody else, then obviously they will control the affairs of the party in that sense. But really, they are not really the party. The party is the party which, gave them the tickets. The party is the one which decided who should contest from where. So I think this is also a very correct decision by the Supreme Court, that it's the party alone which should decide on the whip and not the chief of the legislature party. Because if the chief of the legislature party suddenly decides to defect, then the whole anti-defection law will go for a toss. So the party should always mean the party, political party, and he may not be in the assembly at all. The person controlling that may not be in the assembly at all, and that decision should be final as far as the whip is concerned. So I think that's a very good decision in this case. But the real rub will be if the speaker can decide the disqualification in a couple of days. And if that permission is not given or allowed for the speaker to go ahead, and if someone technicalities, and if a long drawn hearing is to be given before a disqualification is to be passed, then the whole purpose of this 10th schedule will be defeated. So the speaker should have some kind of a summary jurisdiction. If you don't attend the party's meeting, even after a call by the political party, and if you disobey the whip, the speaker should be able to disqualify you on that ground alone. And only a proper medical certificate or, hospitalized or something very, very serious of that kind should be a ground for you to justify your non-presence. And in case of voting, of course, even that will not suffice. So obviously, if that decision is immediate, this anti-defection law will have teeth. So a decision should be immediate.
Right.
And number two, once a person gets disqualified, should not be allowed to enter the same
Yes, you
house.
made that point, Vikas Singh ji. I just want to understand. Another aspect is the comments made on the governor, and that his actions are wide the constitution.
So in a sense, I totally agree with the concept that the governor should be impartial. So if you see the original constitution and the way a constitutional position has been created of a governor or of the president of India, they are supposed to be above party. They are not supposed to act as the representative of a political party which appointed them. Once you get appointed to the post of the governor, you should be above the politics of the state, and you are expected to be a statesman. And unfortunately, the way the governors are appointed and the way they are removed and the way they act has actually eroded the confidence that the people should have in the office of the governor, and the governor has become party to the party politics, and which is very unfortunate. And I think the comments of the Supreme Court are very, very necessary to ensure that firstly that a proper person is appointed as a governor. Invariably, it should not be a political person. And secondly, the governor, once appointed, even if of a political party, should shed his political color and act independently.
Point well made.
To hold the high constitutional, standards that is supposed to be maintained by the governor. Under the
very fair point made, Vikas Singh ji. Thank you very, very much. Quickly going across to Sudhir Mungantiwar ji, the Minister of Forests in the Maharashtra government currently. सुधीर मुनगंटीवार जी नमस्ते, जय हिंद।
नमस्कार, वंदे मातरम।
वंदे मातरम सर, मैं आनंद नरसिम्हन बोल रहा हूँ। मैं आपसे जानना चाहता हूँ आज के फैसले को आप कैसे देखते हैं? हाउ डू यू सी?
देखो ये फैसला जो है जी वो तो बड़ा नैसर्गिक रूप से आया है, क्योंकि जिस विषय को लेकर बार बार ये अटकलें लगाई जा रही थी जी कि सरकार जाएगी, अपात्र किए जाएंगे सदस्य, तो ये बात तो सही थी कि अगर 100 वकील खड़े हो गए कि सूरज पश्चिम से सूर्योदय होता है और एक वकील पूर्व से होता है ऐसा कहेगा, तो मुझे लगता है कितने वकील कहाँ से खड़े हैं इसके आधार पे निर्णय नहीं किया जा सकता। यहाँ पे 16 जो विधायक है वो विधायक पार्टी मीटिंग में नहीं आए, तो पहली बात तो व्हीप पार्टी मीटिंग में लगता ही नहीं। दूसरा विषय ऐसा था कि सदस्य को अपात्र या पात्र करने का अधिकार, ये सुप्रीम कोर्ट बहुत ही असाधारण परिस्थिति में इसका उपयोग कर सकती है। साधारण परिस्थिति में विधानसभा के जो अध्यक्ष है उनको ही अधिकार रहेगा, और इस कारण पात्र अपात्र सदस्यत्व को रद्द करना, ये बातें, ये कुछ लोग ये सोचते थे कि हम इनको अपात्र करके हम फिर से सत्ता में बैठ जाएंगे, मगर ये बात सही थी ना। उनको जनादेश था, जनता ने उनको चुन के भी नहीं दिया था। कांग्रेस राष्ट्रवादी तो 100 के अंदर नजदीक पास आई थी, और शिवसेना भारतीय जनता पार्टी 161 विधानसभा के साथ में जनता की सेवा के लिए जनादेश प्राप्त करके इस 5 वर्ष के सेवा और सरकार चलाने की
जी। तो ये नैतिकता का हवाला उद्धव ठाकरे जी नहीं दे सकते, ये आप कह रहे हैं सुधीर जी, लेकिन कहीं ना कहीं कोर्ट ने ये भी कहा कि गवर्नर ने भी संविधान का मान नहीं रखा, संविधान के विपरीत उन्होंने फैसले लिए।
देखो, इस विषय में अगर आप संविधान पढ़ोगे तो संविधान में बड़ी स्पष्ट ऐसे राज्यपाल और राष्ट्रपति महोदय को अधिकार है। अब सुप्रीम कोर्ट ने कोई ऑब्जर्वेशन किए होंगे, और वो भी मेरे ख्याल से 5 जज की बेंच थी, तो इस ऑब्जर्वेशन पे संसद चर्चा करे। पर संविधान ने बड़े स्पष्ट रूप से महामहिम राज्यपाल महोदय को ये अधिकार दिए हैं। जैसे हम सुप्रीम कोर्ट के जज को कुछ अधिकार देते हैं, ये उनके विशेष अधिकार होते हैं, प्रिविलेज होते हैं, तो महामहिम राज्यपाल महोदय को भी वो कोई सुप्रीम कोर्ट कहेंगे वैसा ही आचरण करेंगे, तो फिर राज्यपाल और उनके अधिकारों पे ये तो अतिक्रमण हो जाएगा। और बड़े स्पष्ट रूप में संविधान ने ये कहा है कि राज्यपाल महोदय को संविधान ये अधिकार देता है कि वो अपनी कोई भी सद्विवेक बुद्धि से कृति कर सकते हैं। आज भी राज्यपाल महोदय कैसा आचरण करे इसकी कोई नियमावली करके रखी नहीं गई है। और ये हमने स्वाधीनता प्राप्त करने के बाद जब 26 जनवरी 1950 में संविधान दिया, तब से ये चलते आया है। ठीक है, सुप्रीम कोर्ट ने कुछ ऑब्जर्वेशन अगर किए होंगे तो इस विषय में चर्चा हो, राष्ट्रव्यापी चर्चा हो, राज्यपाल उस पद के बारे में चर्चा हो, उनके कार्यों के बारे में चर्चा हो, उनके अधिकारों के बारे में चर्चा हो, उनके अधिकारों को सीमित करने के बारे में चर्चा हो। इस विषय में कोई आक्षेप नहीं है, मगर संविधान ने राज्यपाल महोदय और राष्ट्रपति महोदय इनको विशेष अधिकार दिए हैं, जिस आधार पर सद्विवेक बुद्धि के आधार पर वो निर्णय कर सकते हैं।
कोर्ट का ये कहना है कि शायद वो अधिकारों का
विद्यार्थी करके मुझे जानकारी है।
जी, मैं जानता हूं, इसीलिए मैं आपसे पूछ रहा हूं सुधीर जी कि आप कानून पढ़ चुके हैं, इसीलिए मैं आपसे जानना चाहता हूं कि कोर्ट ने कहा कि जो अधिकार उन्हें दिए गए हैं उन अधिकारों का भी हनन है और उन अधिकारों के विपरीत भगत सिंह कोश्यारी जी ने कंडक्ट किया है, जिसकी वजह से वो परिस्थितियां पैदा हुई।
देखो, मुझे पता नहीं भगत सिंह कोश्यारी जी का कोई वकील खड़े थे या भगत सिंह कोश्यारी जी ने उनका केस गढ़ा है। अगर सुप्रीम कोर्ट को इस विषय में उन्होंने आक्षेप लिए है तो जैसा मैंने कहा संसद पे चर्चा होगी जी। राज्यपाल महोदय को संविधान ने अधिकार दिए हैं और संविधान के अधिकार के चौकट में ही उन्होंने निर्णय किए हैं। अब सुप्रीम कोर्ट को लगता है कि उन्होंने जो निर्णय किए हैं तो वो चौकट में नहीं है तो संसद चर्चा करे। मगर मुझे ये 100% पता है कि राष्ट्रपति महोदय, इसीलिए हम महामहिम राज्यपाल महामहिम राष्ट्रपति कहते हैं कि इनको पूरे के पूरे अधिकार, विशेष अधिकार है कि सद्विवेक बुद्धि से वो कोई भी कृति और एक्शन कर सकते हैं।
एक प्रश्न है कि अभी 5 मिनट पहले पृथ्वीराज चौहान जी से मेरी बात हो रही थी, वो पूर्व मुख्यमंत्री हैं, कांग्रेस के वरिष्ठ नेता हैं। उनका कहना है कि ये लीगल बैटल अभी खत्म नहीं हुआ, डिस्क्वालिफिकेशन पर जब निर्णय आएगा स्पीकर का तो हम ये लड़ाई लड़ेंगे, तो ये लीगल पेज अभी खत्म नहीं होते दिख रहे हैं। आप क्या कहना चाहेंगे?
नहीं, वो तो लड़ाई लड़ेंगे क्योंकि जनता की अदालत ने उनके केस को, उनके पार्टी को रिजेक्ट कर दिया है। 14 से उनके पार्टी को रिजेक्ट कर दिया है, देश में भी रिजेक्ट किया। ना 10% सांसद ला सकते हैं विधानसभा में। जो पार्टी जब 1 मई 1960 में महाराष्ट्र में पहली बार महाराष्ट्र राज्य निर्माण हुआ तब उनके 213 विधानसभा विधायक थे, वो 44 पे आ गए। उनसे राष्ट्रवादी आगे गई, शिवसेना आगे गई। तो ये बात तो उनकी सही है कि वो जनता के दरबार में, जनता की अदालत में तो चुनाव जीतना उनके लिए नामुमकिन और मुश्किल होते जा रहा है। तो कानून के चक्कर में ही वो चाहते हैं कि हम और आगे जाए, तो जाए वो कानून के चक्कर में, कोई चिंता की बात नहीं है।
अच्छा, देखिए, अभी अक्टूबर नवंबर में महाराष्ट्र के चुनाव में समय है, अगले साल 24 में, लेकिन अभी बीएमसी के जो चुनाव हैं वो तो 1 साल से टले हैं। तो आपको लगता है कि अब वो उसकी तिथि कभी ना कभी आ जाएगी?
वो तो सुप्रीम कोर्ट तय करने वाली है, तिथि की बात नहीं। हम तो चाहते हैं कि ये महीने में चुनाव हो जाए, हम तो पूरे बातों के लिए तैयार है। माननीय एकनाथ शिंदे जी के नेतृत्व में और देवेंद्र जी के मार्गदर्शन में महाराष्ट्र में हम कोई भी चुनाव हो, हम तैयार है, कोई अड़चन का विषय नहीं है। मगर अब सुप्रीम कोर्ट को ये चुनाव के बारे में, ओबीसी राजनीतिक आरक्षण के बारे में निर्णय करना है।
अंतिम मैं आपसे प्रश्न एक ही पूछूंगा, चुनाव आयोग को कहा गया है कि वो भी फैसला ले लें सिंबल पर, नाम पर, जो भी उनके अधीन है, उधर क्या लगता है?
देखो भैया की बात तो सीधी है। हमारे देश में संविधान ने कई संस्थाओं को स्वायत्तता दी है। वो स्वायत्तता देते समय केंद्रीकरण ना हो, बैलेंस हो, इसलिए संसद को कुछ अधिकार है। मगर उस अधिकारों का अगर उपयोग करते समय कोई समस्याएं निर्माण होती है तो सुप्रीम कोर्ट उसके बारे में भी इंटरप्रिटेशन कर सकती है, मार्गदर्शन कर सकती है। हमने शाहबानो के केस में देखा था कि शाहबानो के केस में जब तब की कांग्रेस की सरकार ने गलतियां की तो सुप्रीम कोर्ट ने उस विषय में कुछ बातें बड़े स्पष्ट रूप से कही है। तो देखो, ये चेक एंड बैलेंस की बातें हैं। तो इस विषय में मुझे लगता है कि चुनाव आयोग ये भी स्वायत्त है, ऑटोनोमस है। तो वो चुनाव आयोग निर्णय करे। अगर हर बात में हमने स्वायत्तता को रोक दिया तो मुझे लगता है फिर चुनाव आयोग भी क्यों चाहिए? वो तो राष्ट्रपति निर्णय कर सकते हैं, प्रधानमंत्री निर्णय कर सकते हैं, पर ऐसा नहीं होता। आपको भी पता है 12 जून 1975 में वो हाईकोर्ट थी जिन्होंने प्राइम मिनिस्टर को अपात्र करने की बात।
थोड़ा रिलीफ तो,
प्राइम मिनिस्टर भी हाईकोर्ट को
रिलीफ तो दिख रहा है कि महाराष्ट्र के कावी सरकार के कई सारे नेता, देवेंद्र फडणवीस को भी इतना खुल के हंसते हुए हमने बहुत दिन से नहीं देखा, एकनाथ शिंदे जी को हंसते नहीं देखा, आपको इतना हंसते नहीं देखा। यानी काफी कुछ टेंशन जो है आंतरिक वो भी थोड़ा संपन्न हुआ है।
भाई साहब, ये एकदम मिथ्या बातें हैं। कल मैं देवेंद्र जी माननीय मुख्यमंत्री जी के साथ मैं खुद लातूर हम गए थे
जी।
हम तो हंसते रहते भाई।
हाँ।
सत्ता का हमें कोई मोह नहीं है, सत्य के बारे में हम काम करते हैं।
हाँ।
सत्ता का कहाँ मोह है?
हाँ।
सत्ता के लिए काम करने वाली ना हमारी पार्टी है ना जनरेशन है।
हाँ।
हम सत्ता के लिए काम नहीं करते। हमारा हमेशा यही हमको सिखाया गया पार्टी के नेताओं के कि पथ का अंतिम लक्ष्य नहीं है सिंहासन पर चढ़ते जाना, सब समाज को साथ लिए हमको है आगे बढ़ना। भारतीय जनता पार्टी ये एक परिवार है, बाकी पार्टियां परिवार की है। वो इंदिरा इज इंडिया कहते हैं, इंडिया इज इंदिरा कहते हैं। वो तो अपनी एक मालकियत चाहते हैं, अपने परिवार से बाहर जाना नहीं चाहते।
देखिए
बहुत पत्थर रख के अभी वो राष्ट्रीय कांग्रेस का अध्यक्ष किसी अलग को बनाया। जब कांग्रेस की विभाजन हुआ तब भी उन्होंने कांग्रेस इंदिरा कांग्रेस नाम रखा। देखो ये मालकियत वाली 7/12 लेकर काम करने वाली पार्टी है भारतीय जनता पार्टी। यानी जनता के साथ बहुत ज्यादा प्यार, भारत के जनता की पार्टी, भारत के जनता की प्रगति,
मैं बस इतना कहूंगा
वाली पार्टी है। चेहरे पे हमारी सत्ता, हाईकोर्ट, सुप्रीम कोर्ट के जजमेंट, इसका दबाव हम पे कभी नहीं रहा।
जी सुधीर मुनगंटीवार जी बहुत बहुत धन्यवाद। भारतीय जनता पार्टी पर जनता का भरोसा है कि नहीं, कर्नाटक में भी देखने को मिलेगा शनिवार को। तब तक के लिए महाराष्ट्र में जो हुआ उसके लिए शुभेच्छा। आपके लिए तो अच्छा हुआ, अब जनता के लिए आप अच्छा करते हैं कि नहीं वो देखा जाएगा। धन्यवाद हमसे बात करने के लिए, बहुत बहुत धन्यवाद।
बहुत
नमस्ते।
बहुत